Hello everyone, Tony Vellini. Thank you in advance for watching. I will be talking about tech education for law students in this video. A little bit about myself. I've been teaching at DePaul College of Law for nearly 15 years, but I'm also completing my master's in cybersecurity with a network security concentration. I've also spearheaded the law school's IT cross-listing initiative. I work closely with our executive director of our IP program, Ellen Gudiantov, to allow any upper-level law student to take select IT courses and have those count for JD credit. I teach a variety of courses, including data privacy law, which is interdisciplinary. I teach both tech and law in the same course, and I test on both of those concepts, and I'll talk more about that later. First, I want to start off with the need for tech education for future lawyers and make an analogy to learning Spanish. So, I want you to imagine a marketplace where many clients are speaking Spanish and most lawyers don't. And most legal educators don't speak Spanish or they're struggling to speak Spanish. The number of Spanish-speaking clients is growing at an exponential rate. There's significant non-lawyer Spanish-speaking professionals responding to the need for legal services. Imagine the opportunities for Spanish-speaking lawyers. Imagine the necessity for law students to learn Spanish. Now, obviously, I'm talking about IT, but I'll use this analogy intermittently. And the solution to me is fairly simple. You need to teach law students some Spanish and also determine the appropriate depth of Spanish education while you're training students in the law. And on my next slide, we'll see that we probably can't keep up with tech, but I believe we can give law students a basic foundation in tech for future learning outside of law school. And so this is how I visualize technology. Practitioners in courts are struggling to keep up. And then I tend to visualize law schools at sort of the tail end, waiting for the case law to come out and then teaching the case law. Now, tech seems to grow at an exponential rate. In my mind, the best evidence of this is that we're running out of IP addresses, specifically IP version 4, which was developed in the early 1980s and which we're using today. Now, what's interesting is in 1980, the U.S. population was roughly 225 million, and IPv4 has a theoretical address space of 4.3 billion possible addresses, and so folks probably thought, well, that's plenty of IP addresses, but they weren't thinking about smartphones and the Internet of Things and cars and refrigerators connecting to the Internet, and so in a few years we're going to run out of IPv4. Now that's okay, we have IP version 6, will replace IPv4, and so it's okay. But again, this is an indication of tech just growing at an exponential rate, running out of IP addresses. And so we can't really keep up with tech, and law schools have limitations. We have to continue teaching historical case law because this is essential. You need to learn the history of contracts to understand the principles. And we probably can't turn a law school into an IT school and expect students to pass the bar. But again, I think we can provide some tech foundation in terms of language and concepts. And so why the language analogy? Well, here's a fun word for you. Xenoglossophobia, a fear of foreign languages. And so, when attorneys are confronted with this foreign language of IT, you might see this reaction, oh my gosh, I don't know what this tech issue is, keep it away from me, I'm scared. And so, lawyers can't bury their heads in the sand anymore, especially given the ethical rules requiring technological competence. But yeah, this language analogy, IT is really its own language. Most businesses speak IT. Attorneys who want to serve those businesses should learn some IT. So, let's think about this language issue. Let's say you have a client who says, well, we bought a layer 3 switch that is having a DHCP conflict with a server running a particular version of Windows. Wow, that's a lot to unpack for most attorneys. What's going on? What's a switch? What's the difference between layer 2, layer 3 switch? What's DHCP? What's a server? What's the relationship with the, these features and other equipment? So the idea is you need to understand what's going on from a tech standpoint before you can assess the legal issues. You want to look at the legal issues, breach of contract or warranty with manufacturer or vendor who installed the equipment, figure out copyright issues as to a software patch that's being written to fix the issue. But again, you can't really do the legal work until you understand the tech, and that's time consuming if you've never learned anything about these tech issues before. And so language learning, it's not a perfect analogy. Because in my final bullet here, achieving tech fluency is more than word substitution. You actually have to learn foreign structures and foreign processes. So Noam Chomsky significantly advanced the field of linguistics in the late 1950s, and a core observation is that languages are largely, nouns or structures in combination with verb phrases. And so I can oversimplify language learning and say, well, it's substantially word substitution. So if I want to learn how to say, I would like a coffee in Spanish, I know what coffee is already. I need the Spanish word café. I also have a variety of requesting phrases such as I would like, and I can substitute the words me gustaría un café, and there you go, you get your coffee. But again, it's more than word substitution. I have to learn foreign structures and processes, and so when I teach tech in my data privacy course, I have to show these foreign structures. And so I teach, for example, formation of a DMZ, a demilitarized zone, using 2 firewalls. And so I teach sandwiching servers between 2 firewalls as one option for forming a DMZ. And so DMZ is a demilitarized zone. You could think of the neutral territory separating North and South Korea. So if we look at this diagram, there's an internet-facing firewall on the right, and that protects the servers in this DMZ area. And then there's an internal firewall that protects the inside network. And so again, I show these sort of concepts, and I even show students how to form a DMZ using only one firewall where there's a DMZ interface. But enough about that, let me keep moving on. Other issues with firewalls, I'll show a basic network architecture, and I'll show, okay, here's the bad guy's IP address, here's the firewall, and I'll, in the next slide, I'll show the basic, really basic oversimplified rule set for how firewall rules work. And these are important concepts. If you just, let's say you're a lawyer working on the 2019 Capital One breach, I guess what happened is there's an allegation that Capital One mismanaged its firewall rules. Amazon Web Service, the cloud provider, is saying, look, Capital One, you mismanaged your rules, it's not our fault. Who knows, maybe Capital One could fire back and say, well, Amazon, you should have alerted us to this vulnerability, who knows. But again, to understand or to navigate those legal issues, you first have to understand basics of firewalls. And so, again, I'll teach students how, okay, a firewall can block that bad guy's IP address but allow other traffic. I'll talk about how firewall rules are executed in order, and so I give this oversimplified rule set, rules 1, 2, and 3, and I'll say, look, these rules are wrong, because actually rule number 2 needs to go first because the rules are executed in order. So reject any traffic from rogue IP address, that should go first, because if rule 1 says allow all internet traffic to e-commerce public web server, if that's the first rule that's executed, that allows the bad guy to get in. And so my slide here comments on how the fix is to set rule number 2 as rule number 1. So I just cover these basics at a high level to help students understand what's going on. And so, okay, why learn network security for law? I think one of the best cases in my mind is FTC versus Wyndham, which actually the FTC issued a large fine for lack of firewalls and many other cybersecurity shortcomings. Just about any cybersecurity mistake that you can make, Wyndham Hotel chain was making those mistakes and was fined heavily. Also, as I mentioned, the Capital One breach, learning network security would be helpful for that. And final bullet point, I mentioned this, how can a lawyer assess firewall legal consequences without understanding some basics of firewalls? And so students need to learn the language of tech to navigate current and future legal issues. So I have here a very short list of statutes. I could have made this 2 or 3 times as long, but just a few statutes to think about. So there's HIPAA, Gramm-Leach-Bliley Act, and GDPR all have express statutory cybersecurity requirements. Some other statutes like the FTC Act essentially indirectly require cybersecurity. ABA rules 1.1 and 1.6. 1.1, duty of technological competence. 1.6, duty to safeguard confidential client information. And actually the most interesting bullet to me is the last one. We now have 2 states that require tech-focused continuing legal education for lawyers. And I believe other states are probably going to fall suit in the near future. So a little more on this need for tech understanding. So Peter Swire, internationally renowned data privacy expert, has discussed the need for a new middle layer of professionals knowledgeable in both law and tech. And these folks liaise between upper management and technologists. And he says, look, they could be lawyers or non-lawyers. And so Peter developed this cybersecurity pedagogical framework, and he takes the existing OSI model of computing layers 1 through 7. I'm going to show the OSI model on the next slide, but what Peter does is he adds his layer 8, 9, and 10 on top of this IT framework. And so as we'll see on the next slide, OSI layers 1 through 5 are essentially network layers, and layer 7 is really the programming layer, the application layer for computer programs. So let's go ahead and take a really quick look at the OSI model, Open System Interconnection Model. Again, abstract model for understanding computing. The top layer, layer 7, is the application layer, which implicates software applications, programming, your internet browser, Microsoft Word, all of that stuff that interacts with you directly is at the top, and it's sort of considered the highest layer of intelligence. Layers 1 through 5, the lower layers, focus on networking. And so here at the bottom, you see an Ethernet cable, then there's an internal switch inside a network, and then there's a router, layer 3, which makes decisions on, okay, certain data needs to be sent out to the internet. Layer 4, when we get up here, that's negotiation between two computers on how to transmit information between each other. And so really the OSI model, to me, it's essentially networking and programming. And so if a lawyer wants to navigate Swire's layers 8 through 10, she should develop an understanding of layers 1 through 7. Now, a good understanding, this requires some study. You don't just learn about the OSI model in a 1-hour conference and say, okay, I'm good. You probably need to take several courses and reinforce what these OSI layers mean and what's happening in each layer and different types of equipment. And so it's not a quick thing. Much like learning Spanish, you don't just take a 1-hour course and you could speak Spanish. That would be great if you could. And so this new middle layer, we kind of see this happening. So various web articles will discuss lawyers working with IT, working on interdisciplinary teams. Richard Susskind, in his book, Tomorrow's Lawyers, there it is, references the liberalization of legal systems, such as in the UK, allowing alternative business structures to provide legal services. So Susskind talks about firms like Pricewaterhouse and Deloitte being really successful at providing legal services with these sort of interdisciplinary teams. Something like that could happen in the US, where the ABA ends up loosening its rules. I think that would probably happen if there were enough pressure from clients, Fortune 500 companies putting pressure on lawyers to do that. It could happen. So anyway, returning to this analogy, how much Spanish education would benefit students? And one answer is the more the better. I think the more practical answer is let's achieve some level of helpful fluency. And so I imagine a hypothetical bachelor's of Spanish degree where you've got, let's say, Intro to Spanish 1 and 2, and then a couple of intermediate courses, and then however many required courses are required by the curriculum. And in my mind, once you're at this sort of intermediate range, you might be ready for Spanish immersion or something else. You're getting to the point when you've taken some intermediate coursework, you're at the point where you could listen and comprehend and then respond to some extent. And so that's a foundation. And so taking this idea, if law schools could provide, let's say, a range roughly of 3 to 6 tech-focused courses, this could provide a decent foundation. And in my own experience as a cybersecurity student, after I had completed 5 or 6 IT courses, I could have somewhat intelligent discussions with tech executives on tech issues. So I had enough background in the terminology and concepts. And so I just want to throw a range out there of 3 to 6, just to give people a range to work with, possible range. Okay, so let's look at some language concepts and think about them in this context. So Spanish immersion. So you could have a conference with technologists and lawyers. So we do this at DePaul, and I'm sure other law schools do this too. You could place law students and IT students in the same course, or even business students too. That would be helpful as well. How about this? Hire a translator. Well, 2019, Georgetown hired a non-lawyer computer scientist to join its full-time law faculty, which I think is so cool. And Professor Blaze will teach innovative interdisciplinary courses at the law school. And so that's great. You hire a translator. Certainly if you have JD professors with tech background, that's another option to teach some of these tech concepts. How about a semester abroad? Well, certainly law schools could encourage tech-focused internships, whether that's at a law firm, an in-house position, a consulting firm like Deloitte, technology firms, for example, maybe a tech startup, who knows. Spanish for lawyers. Okay, well, so various law schools offer programming for lawyers or coding for lawyers courses. This is great. Keep up the good work. I like it a lot. Another option to think about is cross-listing introductory programming and networking or other tech courses from a university's computing school. And that's what I've done with DePaul, well, me and Ellen Gudiantov. And we've done this, one course is Intro to Programming. And so the benefit here is that law students could practice communication, their communication with IT students and IT professors. And another idea, a good computing school is very likely to offer good depth of IT instruction, really teach the tech. It's possible you could have some law professors out there who teach a tech-focused course and, maybe 95% of their focus is on the law without a lot of tech, sort of a siloed approach. So it's just something to think about, a cross-listed IT course as an alternative to a IT for lawyers course. But both are great, conceptually. How about Spanglish? Mix of Spanish and English. So you could encourage interdisciplinary law courses with a substantial tech component. And so second bullet, teach and test. This is very important. Test the tech concepts as an area of competence. And so on my final exam in data privacy, I might have questions like briefly describe how DNS works or how a VPN works, or multiple choice questions on public key encryption. And so testing is very important. And so I list a variety of topics from my data privacy law course. And of course, I've got a network security concentration, in my academic background. And so that's what I'm focusing on here. And it fits pretty well. So I start off with how the internet works. And I'll talk more about how the internet works later in this presentation. But besides my data privacy law course, I'm working with Professor Karen Hart from our computing school on development of a cybersecurity law course that will have a good programming and digital forensics focus, and we'll look at things like security by design and default. And so this is kind of a Spanglish way of approaching things. So we'll teach the law and the tech in both of these courses. And so putting all these ideas together, my proposed curricular priorities that law schools could think about: main priority, provide under-the-hood instruction in networking and programming with an emphasis on security. Now I say emphasize security because it's possible to learn networking and programming without any security emphasis, but security is so important in the law, it needs to be emphasized. Let's talk about the benefits. Well, if you accomplish this, this enables a foundational understanding of OSI layers 1 through 7 for effective navigation of SWIRE's human layers 8 through 10. This foundational understanding is probably more important than learning this year's popular legal practice tool. That being said, if you're teaching current legal practice tools, that's great. Keep up the good work. I just think the core priority should be networking and programming instruction. So the implementations, there's a lot of ways to implement this main priority. You could have cross-listed IT courses like I talked about, and or customized for lawyers courses like coding for lawyers, and or interdisciplinary law courses with substantial tech component, again, tested as an area of competence. And then the additional priority is really to provide any additional relevant tech-focused instruction on other tech issues: e-discovery, forensics, IT project management, blockchain, AI, disaster recovery, practice tools. It's kind of a question of What are your faculty interested in teaching in? Who's available to teach? What are students interested in? Those types of factors. And really with these additional topics or courses, this really reinforces and builds upon the tech vocabulary, increases the fluency, probably increases understanding of OSI layers 1 through 7. And again, you could have many possible implementations of this main priority. So for example, if you teach a blockchain course, you could embed substantial networking and programming instruction, and I bet some folks already do. And again, hopefully they're testing on some of these concepts, because I could imagine some law students, if you just teach some tech and then forget about it, it just gets forgotten. So it's probably helpful to test on those topics. So again, this under the hood instruction, something to think about. Millennials often understand the user side of tech, but not the back end, not the under the hood concepts. And so there's this sort of myth of the digital native. Sure, young folks know how to use Instagram and stuff like that, but what's going on under the hood? And I already talked about the second bullet, so I'll skip that. But the brilliance of Swire's model is that if you learn OSI layers 1 through 7, this is useful for managing all areas of tech, not just cybersecurity. And so, if a lawyer is working on a contract for IT products and services that doesn't necessarily deal with cybersecurity, understanding computing, OSI layers 1 through 7. Again, what are layers 1 through 7? How computers operate, that's programming. How computers talk to each other, that's networking. If you understand these concepts and the terminology, you're in a good position to do all sorts of things when it comes to tech law. And so one author, I was looking at an article, she said, look, students with a computer science degree are better prepared for future legal practice than other students. I say, okay, I think most folks might agree with that. But a question I was looking at is why? These folks are probably not doing the IT work. And my answer is they really have the tech fluency to handle the legal tech issues. So they're in a really good position to brainstorm on software development, whether it's for security by design under GDPR or emerging law in the US, legal process design, assessing incident response, data breach suits, cybersecurity compliance under different statutes. So it's all about tech fluency. And my point is that a law school, I believe, can provide some level of tech fluency without a joint, JD, Master of Computer Science degree, because after all, most law students don't want to do all that work of a joint degree, but if you at least give them the option of a few helpful courses, I think that's a step in the right direction. Final pedagogical thought. So I presented most of these slides at the IP Scholars Conference hosted at DePaul not too long ago, and Andrew Maschernia suggested exploring the concept of whether learning one discipline enhances one's abilities in another discipline. So you might read about things like, if somebody learns chess or music, does that make them better at mathematics or something like that? And I might explore this idea in the future because I think it's really interesting, and I'm sure there's got to be some stuff written on this, so I'll probably explore that. Now, a side note, law schools trying to keep up with tech, trying to adapt their curriculum to the changing marketplace. There's this idea that law schools require radical change to adapt. According to Gartner, most businesses are expected to use this Agile project management model for innovation. And there's a great TED Talk on Agile project management. I believe the speaker's name is Sutherland, and he talks about turning around a manufacturing company using these management principles. And I'm thinking, law schools could potentially explore this radical agile management model because it's really taking over in the business world. So maybe a law school could bring in a consultant to see if some of the agile culture could be implemented. And what makes it radical? Well, you have small, empowered, autonomous teams, adaptive and iterative project management. So rather than getting approval of all details up front, you just start working on it and adapt as you go. It's reported to have less bureaucracy, fewer meetings, higher employee satisfaction. Well, it sounds like a utopia here. Perceived by traditional managers as radical anarchy, so hey, bring it on. Agile, now it might not be a perfect fit for law schools because typically law schools operate with a democratic governance, faculty taking a vote on major decisions, and a business has more of a top-down management. But I think there could be some value in exploring this management model to see if it could help law schools in some way. Okay, let's talk about some tech vignettes, some tech concepts from my data privacy course, and some tech concepts from our under development cybersecurity law course. Some of the things I think about with teaching tech: a 30,000 foot view is useless. So if I say, hey, you know, the internet is made up of connected computers, that doesn't help anybody. But if I could dive down to 10 to 15,000 feet without getting into the weeds, but giving some good details, I think that's helpful. And again, I teach and then test on basic tech concepts. I also look for opportunities to embed hands-on exercises to reinforce understanding of tech concepts. So I start off in the first week of data privacy with the topic of how the internet works. And so I've spoken with tech attorneys who said, look, the first thing I do is I teach a new associate how the internet works. And actually, I think it's a great starting point for introducing tech concepts. And so I do a 45-minute lecture on various details of how the internet works. And so I provide a context of a student walking into a classroom. This is the user experience, right? Student walks into a classroom, powers on laptop, logs onto school's network, opens their internet browser, visits remote website. And again, I go through the behind the scenes technology steps, and I'm thinking, you know, this could be really, really useful for data privacy. Imagine a data breach suit where you're reading an expert witness report that talks about a lot of the concepts that are relevant to this activity. And so I'll jump to my next slide. Don't get scared. I go through all these steps in a 45-minute lecture. I talk about powering on the laptop. Step 2, BIOS loads the operating system into RAM. Step 3, wireless login to enterprise network. Step 4, router DHCP server leases temporary private IPv4 address to laptop. Open browser. 6, type Amazon into browser bar. 7, laptop queries enterprise DNS server for the IP address. 8, laptop reaches out to port 443 for HTTPS. Okay, I'm just going to stop there. Anyway, you can look at this slide, pause the video and look some more if you like, but you know, I think I'm providing a lot of helpful details here to get started on tech, and then later in the course, you know, I'm also, as I go through each of these steps, I introduce the OSI model, I talk about the client-server model of computing, all sorts of helpful things. And then later in the course, I kind of add on to it with other tech ideas. But I think it's a pretty good way to get started with teaching tech. And again, I had a prior slide. I cover a variety of other tech issues, covering some forensics issues. So I'm working on the development of this new cybersecurity law course with Professor Karen Hart, who's with our computing school. She's a lawyer and a computer programmer and teaches cybersecurity courses, and so we're having a lot of fun developing the topics right now. And so one topic is we deal with metadata, data about a file, such as date created, date modified, author, GPS location of a photo. You know, metadata is really important in e-discovery production. So here's a metadata concept. So here's a picture I took in my backyard. And if I were to text you this picture, you could download a free iPhone app and determine the GPS location. You could find out the location of my house if I texted you this photo. So there's definitely some privacy issues there. So you might want to scrub that metadata. If you're operating a dating website, you want to scrub the metadata, for example. What's interesting is John McAfee, the inventor of the McAfee antivirus software, he was actually tracked down by authorities. He was traveling around with a reporter. He was wanted by the Belizean police, and he was traveling with the reporter, sort of thumbing his nose at law enforcement. And the reporter, you know, took this photo and put it online and forgot to scrub the metadata. So, you know, law enforcement just said, "Oh, there's his location. He's right there in Guatemala, next to that restaurant." And so they were able to track him down that way. Kind of ironic because McAfee, of course, cybersecurity expert. So again, I mentioned, dating website, what do you advise your clients? Scrub that metadata. A lot of scenarios where metadata could be useful in civil or criminal action. I was reading this article about metadata, wrongful termination case. They had this employee performance evaluation. They said it was created before the employee was terminated, but the metadata showed otherwise, that the date created was a month later. And so metadata can come up in a variety of contexts. Another thing we're looking at is MD5 hash values. So you can generate a unique hash value for any file or any hard drive. And I don't know how much I want to say out of this. I think I'm starting to run out of steam. But an MD5 hash value is essentially a digital fingerprint of a file or a hard drive. If I calculated an MD5 hash value of every computer in the state of Illinois, will every computer have a unique value? The answer is yes. It's really lottery odds to have two computers match. And even if you make small changes to a file, if you take the MD5 hash value, the value is going to be very different, even with small changes to the data. And so I guess I could just say that this is really important for sort of chain of custody. If you're a digital forensics person, when you take an image, you make a copy of the defendant's hard drive, the digital forensics person records an MD5 hash value at the time of collection. And so, basically, if the other side alleges, no, you altered the data, you could say, no, I did not. Here's a copy of that hard drive with the same MD5 hash value that I recorded. You can go ahead and reproduce all the results of our forensic testing. So it's really a chain of custody issue. Forensic examiner, you arrive at a crime scene. Victim's laptop is on and logged in. Should you power off the laptop or immediately collect forensic image? Need to take a forensic image right away for a variety of reasons. You might lose data that's in RAM. It might be hard to restart and log on. What if the laptop has local encryption and you don't have the password to get in? It's much better to take that image right away. Some of the other topics to be covered in cybersecurity law course, deletion of data, the concept that deleted files still exist in unallocated memory until overwritten. So evidence of secured deletion and spoliation of evidence, the adverse inference rule, security by design and default with regard to software and other things, understanding common attack vectors. I might want to look at potential liability for honeypots. That might be interesting. So anyway, that was a taste of some tech instruction and other ideas. Thank you so much for watching, and I look forward to any comments you might have.